I think we're ready finally to get started, so if I could have your attention. We are absolutely delighted to see all of you here. My name is Becky Safrick. I'm the Interim Community Development Director for the City of Greeley, and we have been interested in reigniting these homeowner association workshops. We got so much information and feedback from folks in the past that a little bit of help knowing how to organize and run your HOAs and just knowing what the rules are really important. So this is the first of 4 HOA workshops that we'll be doing this year. Hopefully you all picked up information from the fire chief. I'll be introducing him in just a moment. And in your packet is some more information from the City of Greeley, which includes the other workshops we'll be doing later on. We'll be sending you out an email to let you know about these as we get closer, so you can sign up again and we can kind of plan accordingly. Feel free anytime throughout the evening if you need another snack to help yourself to that, but we'll be taping this so that we can also post it on YouTube, so if you need to come back later and refresh, you're able to do that. What I'd like to do is introduce Chief Brian Kuznick, who will like to give you a few words about fire safety and his role, and then we'll introduce our speaker and go from there.
Thank you, Becky. Let's be perfectly honest here. I came here to deliver a fire safety message, but also grab a sandwich too. I just got to be transparent and upfront. I'm Brian Kuznick, Fire Chief for the City of Greeley, and it's a privilege for me to be here and share just a few words with you all. I had asked Becky if I could have about an hour to kind of go through some things and highlight the fire department, but she said probably 5 minutes, Brian, is all you've got. So I'm going to make this quick. And I'm sure I'm going to miss a few things, but bear with me. But I want to just introduce myself to all of you. I've been in the fire chief position for 2 years, but born and raised in the Greeley Fire Department, if you will. I've been in the Greeley Fire Department for 24 years. I love this community, I love this fire department, and I'm committed to making sure that we provide the highest level of service to our citizens and those who travel through our community. We are on a quest to become a fire department that delivers world-class service to our community. And we are committed to doing that through professional, compassionate service. And while we are very proud of the work that we do, we know that our ability to deliver the higher level of service really comes from our community members. And so I'm asking you all to do your part to help us keep the City of Greeley a fire-safe community. So an important statistic that I'd like to share with you is that on average, every year, there's 3,000 deaths that occur across the United States as a result of a structure fire, a fire in somebody's home. And over 400 people lose their lives every year as a result of carbon monoxide poisoning in their home, the colorless and odorless gas that is poisonous. So I'm here to remind you all on the importance of having a working smoke alarm in your house. And ideally you would have a smoke alarm in every bedroom, outside in the hallway of the living spaces, and in any common area in your home. So I'm here to urge you and ask you that, one, you please check for those smoke detectors. If they're not in place, I would ask that you kindly work to make that happen. If you have smoke detectors in place, I would ask that you kindly test those smoke detectors and replace those batteries. We typically remind our citizens to replace their batteries every time we change the clocks, and if I'm not mistaken, it's coming up, March 12th, if I'm not mistaken, at 2 a.m. So you might want to do it before 2 a.m. or at least the next day. And then make sure those carbon monoxide alarms are in place. What I've asked Becky, Ms. Safrick here to do is, we're capturing your information here, and I'm going to send out a reminder, a letter on behalf of the Greeley Fire Department with a few reminders. And in that, we'll highlight everything I just spoke about. And then you've also received a handout as you came in, just a little reminder on grilling and safety as you use your barbecues as this weather starts to warm up and we get outside. So please, we're working to make sure that we don't experience a fire fatality or any injury as a result of fire in this community. And regardless of how proud I am of our organization and how capable I know our fire department is, we can't do it without you. So thank you all for the time, and if there's anything I can ever do or provide you You will have my contact information, and you can call me directly on my cell phone or shoot me an email, and I will come visit with you, and we will figure it out together, okay? All right, I hope you have a great meeting, and thank you very much for your time.
We're going to try to speak as loudly as we can. I will, in the meantime, see if we can find a microphone for some of you in the back that may have a hard time listening, but there's also a few seats up closer if that would help anyone. Again, thank you for coming. We are interested in giving you as much information as we can to help you have successful HOAs and healthy neighborhoods, and know how we can work together to make sure that you get performance from your HOA and know the rules, so that we can all kind of communicate on a level that helps us really achieve what we all want, which is the quiet enjoyment of our neighborhoods and our community. We're really pleased to partner up with Altitude Law, which is a service that we've done before. Melissa Garcia is here to present tonight's program, and I'll let her introduce herself, but at the back of some of the information in your packet, there is her larger bio, and you can certainly read that at your leisure. Melissa and her partner will be here doing all the presentations this year, and we've got one scheduled, one per quarter. We're starting out with 101 because we think everybody, after a couple of years of not having this kind of information, could use a primer, and then we'll get into kind of nitty-gritty and tougher stuff throughout the year that is a little more challenging to work with. Again, very happy that you're here. Please feel free to access any of the information, and if you have questions after the workshop, certainly feel free to get back in touch with my office and we will follow up. We are taping the presentation tonight, so if you had somebody that you're aware of in your group that wasn't able to come or would like to see this, we'll post it on YouTube and let you know where you can find that. With that, Melissa, I'll let you do.
Thank you. Hi, everybody. How is everyone tonight? I'm going to yell. If she finds a microphone, even if she doesn't, I will yell, because I can yell for 2.5 hours straight. So thank you so much tonight for coming. I know there's probably, I don't know if there's, I'm not a sports person, so I don't know if football's done or maybe basketball's started. I don't know. Whatever you are missing tonight, I really, really appreciate you coming tonight. I don't know how many people in the audience are board members thinking of being board. Raise your hand. Oh, wow. Okay. Any managers? A few? Okay. Any homeowners who are thinking of becoming board members but are not board members yet? Okay, lock the doors, everybody, because you know that's like nobody ever wants to be on the board. Anyway, thank you so much for coming tonight. My name is Melissa Garcia, and I am one of the partners over at Altitude Community Law. If you didn't get a handout, they're up here, but I'm also going to go over it on the screen here. But all we do is HOA law. And this is not something that we ever charge for. It's something that we try to give back to the community. If we have better leaders and we're going to have better community, there's going to be more transparency and better associations. So that's what we've been doing since the inception of our firm, which is almost 35 years old. So I appreciate you being here. There's a lot of material that we're going to go over tonight, but I do want you to feel free to raise your hand. I'm trying to answer as many questions as I can tonight. And even if I don't get it throughout the presentation, I'm going to stay later and I will answer anything after the class as well, okay? All right, well, we're going to go ahead and get started. And so, first of all, let's go ahead. So we're talking about it says success board member basics, but really it's a foundational class. It doesn't matter how long you've been on the board or if you're brand new on the board. It is something that is useful for any board member, however long you've been on the board. How many people have been on the board for more than 5 years? Wow, you do know it's a lifetime position, right? Yeah. How did you get on the board? You went to the bathroom during the annual meeting. You came out. You were president, right? Well, for whatever reason that you decided to get on the board or you were urged to get on the board, I always want to start with this slide here, which is what is a community association? Because regardless of why you got on the board, you have to remember that you have to take off your homeowner hat, for example, because most board members are homeowners. And you have to think about these 4 things. Number 1, you're a nonprofit corporation. So there is corporate law out there that you have to follow. And if you didn't know that, if you didn't know the statutes, well, we're going to go over a little of them tonight. You are running a business. I think a lot of board members forget when they get on the board, they're there maybe you got on the board because you wanted to make sure the covenants are being followed. Or maybe you didn't like the last board. Or maybe, you want to make sure you know where your money's going. You're paying a lot of assessments. Whatever that is, once you accept that nomination to be on the board, you're running a business, and that means you are running the money of the firm. This could be millions of dollars. It doesn't matter how big the kitty is. You are charged with making sure it's being spent correctly, collected if it's delinquent, preserved, and maybe invested in the future as well. So make sure, what is that? It's like God?
Oh, my stupid, find my phone.
Okay, I'll answer it, or is it just a fine? Okay. Okay, so it's a business. So it's also a community, and I always put community up there because how many of you are on boards where homeowners don't show up to your board meetings? Yeah, does anybody show up to the board meetings? So it's, unless they're really angry at you, and then there's like 100 people at your board meeting. So you have to have your pulse on the community. And even though you're in the board, nobody shows up at the board meetings, but what will happen is you can make these decisions and people think, well, gosh, they're not even thinking about what they're doing. They're not making the decisions, making informed decisions. They just kind of think, well, they decided to levy a special assessment for no reason at all, And because nobody comes to your board meetings, you still have to have your pulse in the community. So particularly when it's something that's really important or something controversial, let's say you're about to repaint the entire community a completely different color scheme than before, even though you as a board member probably have a right to do that, you want to get that input. So it's a community, so people bought into the community for common interests. So you need to remember that as well. And then finally, it's a neighborhood. I always put that on there because neighborhoods, at the end of the day, this is very difficult for board members. When you have a neighbor that's your good friend and you still have to enforce against them. You still have to collect the delinquent assessments. You still have to make the hard decisions where people get really angry at you if you decide to stay on the board. So you have to have a thick skin, in some cases you do. But at the end of the day, it's a neighborhood. And even though there's situations where you might be able to do something and you might have the right to do something, but is it the right thing to do for the neighborhood? So something to think about as well. And again, if you have questions, raise your hands and I'll take as many as I can throughout. So I want to talk about the various roles in the community association as well. These are the players. There's others, I'm sure, but these are the main players, and I want to discuss each one so you understand how they function in the association. So first of all, owners. What do the owners do? So a sort of rule of thumb for board members is that you as board members take action on behalf of the association for everything except what is specifically reserved to the homeowners for a vote. You do everything for the association except what is specifically reserved to the homeowners for a vote. So what do homeowners vote on? Tell me.
Board members.
Board members. Dues. So board members is probably the number one. You're putting your trust in the board to take action on behalf of the association. But the homeowners, what they vote on, it's a very narrow list. Just remember this. It's electing the board. That's probably the most important thing. Second, the budget. Maybe vetoing the budget or approving the budget, depending on what kind of documents you have. Amending certain documents. Voting on specific things that the statute might require you to vote on, like amending declarations. Or if you're going to sell a piece of common area, you have to get homeowners to approve. So there's these things that homeowners get to vote on, but that's it. It's a very small list. Everything else gets acted on by the board. And that's why if you think the board's not doing a great job, then you get on the board. Because the board is supposed to follow and take action on behalf of the association. There's things that homeowners vote on that are driven by the governing documents, which we'll talk about. And then there's things that homeowners vote on that are driven by Colorado law. But if you're at an annual meeting, for example, and somebody stands up in the middle of the annual meeting and says, I want to fire the management company, or I want to fire the landscaping company, or whatever that issue is. That is not something for the homeowners to vote on. That is for the board to vote on. So what you would do at that annual meeting is say, thank you for your comments. I mean, we're going to take this into consideration. Please come to the next board meeting. But it's not appropriate for the board to be deferring actions to the homeowners. It's appropriate for the board to make informed decisions and act on behalf of the association. All right. What does the board do? The board is driven by the governing documents, as I said, and state law. I put those two statutory references up there, and you'll see that on our website, it's on the very last slide, is our website. You can find the two statutes that we're going to talk about tonight, and you can download them. But these two statutes up there, these provisions, these are default powers, default authority of the board if it's not expressly stated in your governing document. So there's a list of things, because some of these governing documents are really old and maybe they have 5 things in there or 5 pages. There's all these things that Colorado law says the association board of directors or the association in general has authority to do. So I just wanted you to point that out to you in case you're wondering, well, what exactly do we have authority to do? A lot of it's in there, even if it's not in your governing documents. So this is everything, pretty much in summary category, but you really need to look at each of your documents to figure out what authority you have. It doesn't matter if you've been on a number of associations, the documents are all different. So don't just think, or managers that are in the audience today, don't just think it's because 90% of the documents say one thing that you can carry it on to the next 10%. So just look at your governing documents and we'll go through each one. But these are, yes?
What takes precedence?
We're gonna get there.
Okay.
All right, just settle down, okay? All right, so it's coming, I promise. So all of these things are summary things, but look at the bottom, oversee managing agent. So you hire a manager to administer your directives. And so on the one hand, one of the things at the very end, I say don't micromanage, because why do you hire a manager if you're gonna micromanage a manager? But you still have to oversee them and make sure that whatever you determined in the management contract is being done correctly and or to your expectations, because they might have different expectations as well. So it's really important whenever you're sitting down with a manager and renewing that contract that you're clear with your expectations, and they are too, so nobody's upset at the end of the day, okay? Also, the managing agent, let me see if that's next. Okay, it's coming up in a second. I'll tell you a little bit more about the managers here in a second. What do the officers do? So the officers, most people think, well, we already talked about the board members. Aren't they the officers? Not necessarily. Take a look at your bylaws, which we're going to talk about. Because the bylaws sometimes say you don't have to be board members to be officers, to be the president, the secretary, the treasurer, the VP. Most of them say you have to be a board member, but some of them don't. So the officers are really positions that board members usually assume once they get on the board. They're things like the president presides over the meeting. The secretary sometimes takes minutes. The treasurer makes sure that the assessments are being collected and deposited, those kinds of things. Most of these things are also delegated to the manager. But look at your bylaws, because that's what specifies what the officers are supposed to do. And any duties of the officers can be delegated to the managing agent or another committee member. I mean, for example, the treasurer, even though the treasurer's responsible for the money, the treasurer, if you have a management company, isn't collecting assessments. That's what the management company is doing. So much of what happens, much of what the officers do is delegated to the managing agent, but you should still know what those duties are. All right, committee members. Who here has, other than an architectural review committee, who here has a committee in their association? Others. What kind of committee? Landscaping committee. Okay, anybody else? Yes. Events committee, great. You had somebody over here?
Well, it was social committee.
Social committee, okay. And in the back? Roads? Okay, roads, okay. So that's great. I usually don't have any hands up, which I think committees are a fantastic way for, number one, the board to take off a little bit of the burden that they have, and to share it with homeowners so that the homeowners have more ownership over the projects of the community. And it's a great way to just kind of spread some of that out and allow them to be part of that process that the board has to go through for various things. And even if you don't have anything in your documents that says that you can appoint committees, you can. That's per Colorado law. You have the right to appoint committees. The only committee I typically see already laid out in the documents is an architectural review committee, which we'll talk about in a second. But you can create all these other committees. If you do decide to create a committee, then make sure that the committee chairpersons meet the same kind of qualifications as board members. What do I mean by that? Board members typically have to be owners. Often they have to be current in their dues, not in violation of the documents. The law was changed to say that committee chairpersons also have to meet the same requirements. So just remember that. And then second, always create a committee charter. If you create a committee charter, that will lay out the scope, the reporting duties, what exactly they're supposed to do, just so everybody knows what they're supposed to do and the information is being brought back to the board regularly and appropriately. So so you know, if you've never been on our website, we have a lot of free stuff on there. I'm pretty sure we've got a committee charter up there, so just make sure you take a look at our website. Okay, finally, what does the manager do? The manager is the administrative arm of the board. The manager doesn't make decisions. The board makes the high-level decisions, and then the manager administers them. They take your directives, and they administer them. Sometimes I see the line between the manager and the board get blurred in terms of homeowners not sure who's making the decisions. They just kind of assume, oh, it's the management company that decided this or that. And that's not the case. It's just because the manager is usually the face that they see and the name on the correspondence. Just if you sense that in your community, you really need to make sure, maybe at an annual meeting or whatever, that you explain the role. The board, the buck stops at the board. The manager just administers those decisions and provides the kind of day-to-day expertise. And maybe there's a certain amount that the manager can spend without board approval because it's in the budget already. But everything is driven by the contract, and the manager really just administers the decisions. I wanted to bring up manager licensing because several years ago, managers had to be licensed in Colorado, and then that went away maybe 2 or 3 years ago. It is going to come back. We're pretty sure it's coming back. There was a bill that was introduced last year but got killed at the last minute, and they're gearing to drop something this year too. So it's probably going to come back, but not in the same form as it was before. But it's really just minimum qualifications for managers to practice in Colorado. Okay, we're moving on. Tools of the trade. Let's talk about your governing documents. Okay, this gentleman here wanted to know what the hierarchy was. Well, here it is. Sorry, it's really blurry there, but you should be able to see it on your handout. This is the hierarchy of enforcement. Now, every single document here is valid and it's enforceable. So I'm not saying that something's not enforceable because it's lower, but every single document here is enforceable. It's just that to the extent of any inconsistency between and among these documents, the higher one is going to control. And it's kind of tricky because you see at the very top it says statutes, but the statutes themselves, which we'll talk about, sometimes will defer to what's in your documents depending on the provision. They might say, the statute might say quorum is X regardless, or it might say quorum is 20% unless your documents say otherwise. So it's, even though they're on the top, it's tricky because some of the provisions will defer to your documents. So the statutes are on the top, then we have the declaration plat. We're going to talk about each one of these. Articles, bylaws, and rules and regulations. This is really important for boards to understand because I see many times boards that are, for example, adopting rules and regs, which is in the very bottom, that are contrary to the declaration. Rules and regs really ought to just clarify the declaration. We'll talk about them in a second, but I see this all the time. The declaration says something like, dogs are, a reasonable number of dogs are allowed. And then the board adopts rules that say no dogs. I mean, that's clearly contrary to the declaration, so the declaration is going to control. I'll give you one other example, which is very common, where I see inconsistency, very common. And that's between the Articles of Incorporation, which is the third one down, and the bylaws. So if I ask you, how many board members are you allowed to have on your board? Where would you typically look? Where do you think? Bylaws, right? That's where, and again, we're going to talk about the bylaws. Typically, you'd look at the bylaws. But guess what? The Articles of Incorporation often say something about board member numbers as well. And I see this regularly, where the bylaws will say something like, you can have up to 5 board members, and then the articles say you can have 3, and the articles will control. So you just need to realize that that's a common inconsistency. So you need to review all your documents to see, and potentially amend if they don't reflect your practice today. So let's talk about each one of these. Now, the 2 statutes that control Colorado, there's other statutes that are useful as well, but these are the 2 statutes that really govern associations in Colorado, and they're at the very top. The Colorado Common Interest Ownership Act, also called Kiowa, and then underneath there, the Colorado Revised Nonprofit Corporation Act. That's a statute that governs all nonprofit corporations, including associations. Of the 2, the top one is really the important one, the one you really need to know. There's a few things in the bottom statute that we'll talk about, but a lot of it is duplicative to what's on top. And the bottom statute really has more to do with operational stuff versus rights, limitations, responsibilities, and all that, which are in Kiowa. And you'll see that there's 2 types of associations under Kiowa. There's a pre-Kiowa association and a post-Kiowa association. Pre-Kiowa is an association that was created before July 1st, 1992. That means that the declaration, the CC&Rs, also called the CC&Rs, also called the covenants, when was that document recorded? That's what tells you when your association was created, when the declaration was recorded. If it was recorded prior to July 1st, 1992, then you're just a pre-Kiowa association, which means you only have to follow some sections of Kiowa. Who here is in a pre-Kiowa association created prior to July 1st, 1992? Most of you are opposed? Really? Because you don't know. Okay, I'm going to tell you to those who you don't know. Write this. Oh, I did put it up there. Good. Okay. So that's section 38-33.3-117. That lists all the provisions of Kiowa that are applicable to pre-Kiowa associations. Post-Kiowa is created on or after July 1st, 1992. That's everything else. Okay? All parts of Kiowa you're subject to if your association was created on or after July 1st, 1992. But the pre, only in that list. Okay? Okay. The plat map. And if you're in a condominium association, the condo map. So the plat, you remember on that hierarchy, it's on the same level as the declaration. It's because they're considered the same document. They were both created, they both helped create the community together. The map and the declaration. The map, all it does is really just tells you which property is subject to that declaration, what's in your community. But it also includes a lot of other fun stuff and good stuff for you. I mean, first of all, it's recorded with the clerk and recorder's office. So in Greeley, that's Weld. So you can get, if you've never seen your map, you can get that from Weld County Clerk and Recorder's Office. But it will tell you where the units are, what the boundaries are. It'll tell you where the common areas are. Who here is in a condo association? Anybody? Okay, so condo associations, it will tell you things like, what are the limited common elements of the community? I mean, sometimes the declaration will say, owners maintain limited common elements, and then they don't define what that means. Guess what? It's on the map. It's going to be on the map. It's going to say balconies are limited common elements, whatever. Sometimes we're single-family home communities. If you don't know who's responsible for that perimeter fence, because it says nothing in your covenants, oftentimes the map will say association maintains fence. So just get a copy if you haven't seen it. It helps. It also sometimes has easement language on there. That just means that language that allows somebody else to use certain property. Maybe there's a trail that goes through the community that everybody can use, or something else. But it's really important for you to get it if you don't have a copy of your map. Now this, the declaration covenant, also called covenant CC&Rs, is the most important document of the association. This is where all the meat is. This document has the use restrictions, how you can use your property. It has the assessment provisions. It has the maintenance provisions, the powers of the board. All of this is in the declaration. Architectural review. Now it's also, this is important too, for let's say you're on the board and a homeowner comes to you and says, well, I never got my declaration. So I never read it. I didn't realize that dogs weren't allowed. Okay? So if you get something like this, this is the only document that courts say you had due diligence to read it before you bought into the community. You can never bring an argument saying, I didn't know it was in there. If it was in this document, it very clearly says something like, no dogs, or whatever it is, then you are held to that. Even if you didn't get it from the seller or the title company, you are held to that. So it's the most important document for both, homeowners who are in the community now, as well as future homeowners coming in. Yes, ma'am?
How about if you have a homeowner that wants to buy and they have a special need and they have 2 dogs?
Oh, we're getting into the emotional support animals, right? No, yeah, okay. So I was going to bring that up as an example, okay? So no, later on, so I'll use it now. So if you have a declaration that says up to 2 dogs, right, or up to 2 pets, but then you have somebody who is disabled and needs an emotional support animal. Who has heard of emotional support animals? I mean, there's emotional support chickens. There's emotional support miniature goats, or there's a lot of emotional support animals out there, right? So number one, you got to remember that emotional support animals are not considered pets. So do not include them in that restriction. You can't. If it says up to 2 pets and they already have 2 dogs, but then they also need an emotional support chicken or whatever, they get to have that, depending on whether they qualify, which I'll talk about in a second. But don't treat them as within the same provisions as pets, because they're not considered pets. They're considered animals for the purpose of disabled people. So just really quickly, because I could talk all night about ESAs and disabilities and all that, but associations are required to provide reasonable accommodations to disabled people. So that means if, for example, somebody is mobily impaired and they need a wheelchair ramp in front of their house, you have to allow them to build that wheelchair ramp, even though you might deny that with everyone else. If they're disabled, they get it. Now, you, as a board, have the right to, well, first of all, if the disability is obvious, you do not have the right to ask for verification. So, for example, in the animal situation, if you have a blind person that needs a seeing eye dog, that's an obvious disability. You have to allow them to have the seeing eye dog, even if you have a provision that says no pets, no dogs, because it's a reasonable accommodation to assist them with their disability. But if you have somebody who's disabled and it's not obvious, PTSD, severe anxiety, diabetes even, because they can help with certain diseases, then you have the right to ask them for verification. That verification can come from a healthcare practitioner. It doesn't have to be a doctor. There's a whole list of ways that they can provide you documentation that says, I am disabled, I need that animal to assist me to have equal use and enjoyment of the community. Once they provide that, then stop asking any more questions, because that'll get you into trouble. So I'm going to move on because that's a class all in itself, but if you're interested in that, let me know. We have plenty of material on that. We even have videos that we talk just about that. All right.
I've got a question.
Yes, sir.
What do you do in situations, because we all signed off on covenants when we bought our homes in
Right.
Dan, and some of the neighborhood was relatively new. The developer turned the homes
property over to the
HOA,
owners, yeah.
but then gave homeowners letters that were contrary to the covenants.
What kind of letter? So the comment was the
Well, it says
developer
like-
after they,
Well, as an example, our covenants say you can't have dark colored roofs like black roofs.
Okay.
Certain color bricks and certain types of fence, and they were all approved by the developer after it was turned over.
okay, so it was contrary to the covenants, right?
Yes.
That is so common. Are there any developers in here? Get up here and, that is really common, and that's a great question, because what do you do? Now, boards, they can't help what developers did before, but they still have a duty to enforce the covenants. So unfortunately, the developer is going to grant variances and do whatever the developer wants to be able to sell out the community and get that sale. What board members need to do is right after transition, if that's happened quite a bit, you need to break yourself free from that. I mean, essentially send a letter to the entire community saying, look, we have the obligation to enforce this moving forward. We're not going to go after what was already provided to the homeowners that got that letter or got the approval, but we are going to enforce moving forward. So just because that gentleman has a shed and no sheds are allowed, we are going to enforce sheds moving forward. So if you're in that circumstance, I would say break free from the prior. It doesn't have to be a developer, it could be a prior board that was not doing it correctly. And just take a stance and say, look, from here on forward, we're going to enforce the covenants as written because we have a duty to do so. We're going to give you a reasonable period of time to comply, and then we're going to enforce it. Or we're going to amend if we don't like, the covenant anyway. That's why we're not enforcing. So, does that answer your question?
Yeah.
Okay, great.
That's pretty much what we're doing, but
Yeah.
it's kind of frustrating that
It's very frustrating that happens quite a bit. Yeah,
next houses in the community simply because the developer.
allowed it.
Yeah, allowed it.
Yeah. Are there any developers in the audience? No.
Your
Okay.
example of the shed,
The shed, yes.
can you, at the time of the sale of the house to the next party,
Make them take it down?
make the original owner tear it out before the house is sold?
Short answer is no, if they were given approval. Okay, if they were already given approval by the developer, no. Because they and any future owner will have a defense called estoppel saying, hey, we bought it and we got approval, we spent money, we're buying this house. However, if they put up that shed or that fence or whatever, and it was against the covenants and they didn't get anybody's approval, but let's say you should hear this, there's a 1-year statute of limitations for constructions. So if somebody puts up a shed or fence or something that's contrary to your covenants and you don't sue them within 1 year, you cannot force them to take it down. But let's say you have a situation where it's really close to the 1-year statute of limitations and you enter into an agreement saying, look, we're not going to sue you as long as you sign this agreement to take it down when you sell. And then you can enforce that agreement. So you're kind of, but for everyone else, if it's up for a year, you can't take it down after that year. So you have to be careful. Okay, let's move on. Articles of incorporation. The least important document, in my opinion, is just, all it does is bring the corporation into existence. It's usually 4 or 5 pages long. And it's just what I like to call the birth certificate of the association. It just establishes the purposes of the association. Like, the association is here to enforce the covenants, to collect the assessments, to maintain the landscaping. It also includes, or should include, limited liability provisions. This is important for board members because this is what protects you if somebody sues you individually. Your articles of incorporation should have something that says, board members are not individually liable for their decisions. Because, I mean, are you getting paid to be on the board? No. So why should you be sued and then held liable for something that you're doing voluntarily? If you don't have that in your articles, you need to get that in there, the limited liability provisions. Also, it establishes the dissolution provisions. One other thing I wanted to mention really quickly, it's not on there, is that especially for self-managed boards, self-managed associations, if you don't have a management company, this might be a problem. Because the Secretary of State is who has all the articles of incorporation. And every year they send out what's called a periodic report request to the person who is serving as the registered agent for the association. Typically that's the management company. Sometimes it's the attorney. But if you're self-managed, it's usually a board member. Maybe it's a president or whomever. If that person leaves and you don't change that on the Secretary of State's website, then the Secretary of State's going to continue to send you this periodic report request every year saying, are you still an association? If you don't respond in 5 years, they're going to administratively dissolve your association. That's why it's really important to know who's the registered agent for your association and to update it if that changes. And that really does affect self-managed boards. If it gets administratively dissolved, that means you no longer have any lien rights, any enforcement rights, you can't take action as an association. Somebody could take the name of your association, so a lot could happen while you're suspended. So make sure you know who that is. You just have to get on the Secretary of State's website and search your association. It'll say on the very first page who the registered agent is. And you can update it easily, there's no fee, every time it changes. Oh, there is a fee for changing the registered agent? Oh, sorry, I stand corrected, I'm sorry. Of course, there's always a fee for everything.
With the Secretary of State, but
yeah.
I don't think it's a fee.
I don't know, there probably is, because why not charge you another fee? Okay, bylaws. Bylaws, I'm going to say, is the most important document for the board. And the only reason why I say this is because this is the one where I see board members messing up all the time. There are so many nuances and so many new things required per Colorado law that are in the bylaws. The bylaws are all operational. Things like how many days for notice of meetings, how do you elect directors, how do you remove directors, how do you inspect records, all of that kind of stuff, that operational procedural stuff is in the bylaws. And because there are so many different micromanaging provisions, this is where I see the board members mess up. If it says that, and this is in Boulder, this was a real provision. It said the annual meeting is on May 1st at 7 p.m. under the council tree. That's what it said, under the council tree. And I had this board really panicking, calling me, saying, which tree is the council tree? Should we put a sign up that says council tree on the tree so we can hold the meeting underneath it? And I said, no, amend that out, because it doesn't need to be there. But if it's there, you need to follow it. And this is the reason why. There's no, statute, there's no Kiowa cop that's gonna fine you because you make one technical violation. But guess what? If anybody's upset at you and they're trying to make an example and they're suing you or the association, their attorney will add everything else in. They might be suing you because they don't like the fact that you levied a special assessment. Well, their attorney is going to say, okay, we're going to sue on that. We're also going to see how many little technical violations of the bylaws or the governing documents did the board commit. Because cumulatively, it could lead to a breach of fiduciary duty claim that might stick. So that's why you really need to know what's in the bylaws, because this is the one document that, when I say the law was changed many times over the last 10, 15 years, it was changed to supersede many provisions in your bylaws. And so you might have this great set of documents that's 20 years old, and you're following 30% of the provisions that are now contrary to Colorado law, or they're missing provisions that you have to know about. So just, if your documents are over 20 years old, you really need to talk to whoever your attorney is about reviewing. Yes?
So I have a question.
Mhm.
As you know, we just went through updating our CCNRs and the bylaws as part of that. And so I'm told that we don't have to record the bylaws.
So,
with the-
so the question is, do you have to record the bylaws? No. No, and you'll see on these slides, the declaration has to be recorded with the clerk and recorder's office. The articles of incorporation has to be filed with the Secretary of State. Bylaws doesn't need to be recorded, just it needs to be with your records.
Has that always been a law?
That has always been the law, yeah.
Thank you.
Yeah, sometimes they record them, I don't know why, but they're not required to be.
Okay, thank you.
You're welcome. Okay, rules and regulations, architectural design guidelines, that's at the very bottom of that hierarchy chart. These are important as well. What rules and regulations, I mean, when you think about covenants or declarations, you see these use restrictions like leasing restrictions or up to 2 pets allowed or whatever. The rules and regulations are really supposed to clarify what's already in your declaration. So for example, if you have a provision that says you can have a reasonable number of household pets, let's say that's in your declaration, your board can take that and adopt a clarification in the rules and regulations. They can say a reasonable number means 2 per unit. Household pets means dogs, cats, chickens, whatever it is, you know. They can clarify that in the rules and regulations, but they cannot be contrary to the declaration. Just be very, very careful about that. The other thing that you need to be careful about as well is if you're a board and you have the right to clarify an ambiguous term like commercial vehicle, what is that? Is that a cement truck or is that a Mary Kay Cadillac with a little sticker on it? What's a commercial vehicle? You have the right to interpret that, but that also means that future boards can overrule your interpretation. So if you want something to stick, if you want no more than 2 pets in that community, you need to get it in the declaration. Because the declaration, once you amend that to get that provision in there, only homeowners can change it. The other thing too about rules and regulations is if you have a use restriction in the covenants, like no pets, it's deemed law pretty much by the courts. The courts are going to say, it's in the declaration, it's clear, you have to follow it. Unless it's somehow contrary to state law, it's valid. They're not going to look any further than, is it clearly stated in the declaration? Rules and regulations, because they're typically adopted by the board, they're going to scrutinize them quite a bit if challenged. They're going to say, is it fair? Is it reasonable? Did homeowners have notice of it? Remember I said with a declaration, they don't care whether you got notice because you have due diligence to read the declaration. They do care with rules. They want to know that you actually published them and circulated them. They're going to ask, is it overbroad? Is it outside the scope of the association? So when you have rules and regs that you're drafting, make sure your attorney reviews them because they're going to look at them to see if they're contrary to the declaration or state law or some other law, federal law. Okay? Architectural design guidelines, similar to rules and regulations, except they only pertain to architectural submissions. You know, somebody wants to change the exterior of their home, and you have a process for them to submit that, and you review it, and then you respond yes or no. I mean, it's similar to the rules and regulations because typically the board approves them, but sometimes the architectural review committee approves them. It's different depending on the document, so just be sure you've read them because it could be the board, it could be the ARC. But it's the same thing. They cannot be contrary to what's in the declaration. One of the things for ARC things that I sometimes see is the declaration says something like, the criteria for review is it must be aesthetically pleasing. It must harmonize with the rest of the community. Something very general like that. But nothing about view. And then the board or the ARC adopts the guideline that says we can reject based on view. that you're gonna lose in court, because that is contrary to the criteria. View has nothing to do with aesthetics or harmony, and we have case law on that as well. So make sure that if view is important, put it in the declaration. Don't put it in the guidelines. Okay? All right. Policies and procedures also on the bottom of that hierarchy. So policies and procedures, the difference between a policy and a rule is policies are really, they're courses of action that are memorialized in a document. So for example, these 9 are required under Kiowa, that first statute I talked about. They're courses of action and clarifications and procedures for each of these 9 topics that the legislature feels is important enough for you to actually formalize into policies. So for example, I bolded collection and enforcement. A collection policy shows what the course of action that association will take if somebody is delinquent in their assessments. It's going to say things like, how many days before I lien them? What kind of payment plan terms am I going to offer? What kind of interest or late fees are we going to charge? All of those details are in the collection policy. Same thing as in the enforcement policy. What are we going to do before we fine somebody for a violation? How many days do they get to cure the violation? What do they get a right to a hearing? All of that is clarified in the enforcement policy. I bolded collections and enforcement because the law was changed drastically last year in terms of how you collect delinquent assessments and how you enforce violations. And if you don't have these policies in place and you take somebody to court, you've already lost, because that's the first thing they're going to ask for, is your collection policy. The second thing they're going to ask is, are you following that policy? You can't just adopt it and then not follow it. Yes, sir.
Would COVID fall under that policy?
COVID policy?
Yeah, I mean, I guess what I'm asking is, if somebody's isn't working because of COVID, so they can't pay their dues and that kind of stuff.
Gotcha. So the comment or the question was, well, what if COVID or other circumstances prevent somebody from paying their assessments or what have you? Yes, there's the policies don't address it, or the legislation doesn't address it, but the board can certainly address it in its practices. If there's circumstances that warrant a longer payment plan, or a moratorium, or something, or waiving all the late fees until, whatever it is, then yes, you can certainly take that into consideration. Okay. All right, so these are the 9 that are required under Kiowa, but there could be other policies that you have and procedures that you put in place. But if you these were actually required to be adopted back in 2006. So there was only 7 in the beginning, and then they add the last 2 in the last 5 years or so. But these have been law for quite some time, so you need to have these policies written if you haven't yet. Okay. All right, we're gonna switch gears and talk about board meetings. Yes?
What about a situation where an owner passes away, doesn't have a will, his estate goes into probate?
Yes. It's very, very, very difficult to collect, if that's what you're asking.
That's what I'm asking.
Yeah. If somebody passes away and sometimes their estate isn't even in probate, that's even worse. But if it is, you have to follow whatever time frames. You're not going to probably be able to get the judgment as easily as you would with somebody that's still living. But you still follow the process. And then typically, because oftentimes you can't even serve the party, obviously if they're dead, but you can't serve the right party or figure out who is in charge of the estate until either probate opens or you find somebody that tries to take the property. So you can't really follow the same time frames as you would typically follow.
The board waive late fees?
Yes.
Okay.
Yes, the board can always, there's always an opportunity for you to waive late fees or interest. And oftentimes, the late fees and interest are supposed to incentivize people to pay. So if they pay, then you don't need them anymore. So you can usually use that as the carrot at the end, or at the beginning, or whatever you want to call it, where you say, if you stay with this payment plan and pay the whole thing, then we'll waive all the late fees. But if they don't, then they all stay on the ledger. So,
Are you
yes.
compelled to offer that to anybody in your
Payment plans are required to be offered
uniformly?
to everyone. Yes, and again, the new law, if you get on our website, there's a whole section on HB 22-1137, and oh my gosh, it's the craziest bill. But there's all these things you have to do, but one of them is offering not just a 6-month payment plan, but an 18-month payment plan. So, yeah. All right, let's move on. Oh, one more.
Bill again?
HB 22-1137. That's like burned in my brain from last year. So if you get on our website, one of the things that you can always look at, we have this thing called the legislative tracker. It's on the very top of the website. It shows all the bills for the last few years and which ones passed and which ones are signed into law. It also tracks the current legislation as well. So definitely take a look at that. You can get the actual link to the bill as well. Okay, let's move on. Board meetings. So I put this up here because I just wanted to make sure everybody, there's things that have been coming up quite a bit in my practice, and I'm finding out that like boards don't know they're supposed to do certain things, or they're doing things incorrectly. So let's just go over a couple of these things in detail. So first of all, I just want you to know the law right now does not require board meeting notices to be given to homeowners. I know that sounds kind of counterintuitive because homeowners have every right to attend a board meeting. So there's a weird loophole in the law that says you don't have to give notice, written notice proactively. It's come up a couple of times in the legislative sessions, but it never passes, and I think it might have to do with the fact that the cost, if you had to mail it, just like homeowner meetings, maybe that's why it doesn't become law. But it'll probably become law soon. So even though you're not required to give notice of board meetings to homeowners, it is a good thing to do. Just publish when you regularly meet as a board, because it goes with the transparency that is very clearly a trend in all the legislative bills, is transparency. So I would probably publish it or send it by email. Don't mail it. Don't spend a lot of money mailing notice. But I would do so even though you're not required to. Just get used to it because I think that's going to become law soon. Quorum, the one thing I wanted to say about quorum was for owner meetings, if you get quorum at the beginning of the owner meeting and lose it before you vote, you can still vote. You can still take action. Not so with board meetings. If you have quorum at the beginning of a board meeting, but you lose it before the board votes, you can't take action. You have to keep quorum throughout the entire board meeting. Okay. Proxies. Owner meeting proxies, homeowners can give their proxy to whomever they want. And even if your bylaws say they can only be given to other homeowners, it's contrary to Colorado law. At homeowner meetings, you can give your proxy to whomever you want, as long as they show up to the meeting. And at homeowner meetings, your proxy can say, this person can vote however they want on my behalf. Not so with board meeting proxies. If you have a board meeting proxy, you can only give your proxy to another board member, and it's only a directed proxy, which means I, board member, direct you, other board member, to vote a certain way on a particular action. It's very different for board meetings. Also, for board meeting proxies, you have to have the right to levy a board or to provide board meeting proxies in your bylaws. It actually has to say board members have the right to vote by proxy in your bylaws. If it's not there, then you cannot vote by proxy at a board meeting. Open to members. All board meetings are open to members unless you're in executive session, which is closed session, which we'll talk about in a second. And that's not just homeowners. Homeowners can designate somebody to attend for them. They can say, I want my tenant to attend the meeting. I want my sister to attend. I want my attorney to attend the meeting. They have every right to do that. That's under the statute. All they have to do is send you an email and say, I designate, it should be in writing, I designate so-and-so to attend the board meeting on my behalf. Special meetings, the only thing you can vote on at a special meeting is something that's already in the agenda. So let's say you have a regular board meeting and then something comes up, you can add it to the agenda. Not for special board meetings. Special board meetings are those meetings in between your regular board meetings. Only what's on the agenda. Working sessions. Has anybody heard this term before? A couple of you. Okay. So it's a trending term and it's not recognized by Colorado law. Colorado law doesn't say you can go into working session. There's no such thing. But this is what it typically means. It typically means that a few board members are getting together, or maybe the entire board, to work through something, but they're not going to vote on it. Okay, that's what it usually means. And the reason why it's come up is it's because if you don't vote on anything, then we don't have to open it up to homeowners, because it's not a meeting. And only meetings are supposed to be open to homeowners. So right now, the statute does not define meeting. So you can certainly make that argument and say, we're not voting on anything, so it's not a meeting, so only board members can be present. And I think you can make that argument now. I think that's going to change. Again, like the notice to all board meetings, I think that's going to change because transparency is the key and the buzzword every single year. And if you are finding a loophole and saying, well, it's a working session, then, you know, it's going to close soon. Yes?
How does that work in the digital age with a lot of board members doing emails?
So that's coming up. Yeah, actually, we're going to talk about email votes, which are not meetings, for one thing. So that's another loophole. And we'll talk about virtual meetings in a second here, too. Yeah.
Can we go back to special meetings?
Yeah.
I kind of missed what you said about that.
Oh, special meetings, the only thing I mean about special meetings is if the board has a special meeting, so it's in between the regular meetings, it cannot take any action at that special meeting that's not listed on the agenda. So you have to know and list on the agenda what's going to be done at the special meeting.
Okay, and then is that agenda out on, is that
The
open
agendas
to
are
public?
all available to homeowners if they
So
request.
they could know that.
So they can know, so they can determine whether to attend. Also, really quickly, the working session, again, I want you to get used to allowing homeowners to come to working sessions because this is going to be law soon. We're following Florida, we're following California. Even if two board members get together, not even a quorum, and discuss HOA business, that's considered a meeting in many other states. And we're getting there, so just get used to it. And if your pushback is, well, if we let homeowners come to our meeting, our 1 hour meeting turns into a 5 hour meeting. My pushback is that's your fault. You drive that meeting. You kick them out if they're hijacking it, if they're interrupting. But allow them to come and just observe the process. That's why they're there. That's the only reason. All right, executive session. Remember I said that you can close sessions from homeowners. This is your privilege. You don't have to, but I would suggest in most of these categories that you close it off from the homeowners. You might have certain homeowners who attend because they're important to whatever topic is, but I wanted to go through the categories. These are the only times that you can go into closed session. All other meeting categories have to be open to the homeowners. So number one, matters regarding employees. Most associations don't have employees, but if you do, you can go into, because most associations have independent contractors. You're not employing them. They're like the management company. Typically you don't employ, they're not your employees, or the landscaper, they're not your employees. They're independent contractors that you hire to perform services for your community. But to the extent that you actually do have employees, you can go into closed session. Management contract, that's the only contract that you can go into executive session for, unless it falls under another category. So don't go into executive session to talk about the landscape contract or the attorney's contract. That's not allowed unless it falls under another category, which might be one of these two next bullet points. Attorney-client privilege discussion. What if I, for example, reviewed your landscaping contract and you wanted to discuss my comments? You can go into executive session because you're discussing legal counsel communication or advice. Or if your attorney's at the meeting, you can go into executive session as well. Yes?
All of our meeting minutes are published on our website.
We're going to talk about what kind of minutes are required for executive
Well,
session.
that's what I was gonna say. If we discuss someone who's delinquent in their dues and has been for a long time, we don't want that in our minutes.
You don't. I'll discuss how to deal with exactly that situation. Yes?
One quick question.
Yep.
The management contract, are homeowners able to have that contract?
They are. Any contract. It's actually one of the, there's a section under Kiowa, if you're interested, this is the records section, okay? Write this down. It's 38-33.3-317. I know. This is what I do on a Friday night. I memorize provisions. 38-33.3-317. The law was changed in Kiowa to list the records that you have to have open for inspection. That's the section of Kiowa that discusses that. And it says all contracts, current contracts, as well as contracts that are 2 years old. Okay, investigation of misconduct, that means criminal misconduct. So any crime that might have been committed or you think has been committed. Here's the collections thing. Here's the delinquent assessment thing. This was changed last year. Matters which constitute invasion of individual privacy. That means if you're going to hold a violation hearing for somebody who's about to get fined, you go into executive session. If you're going to talk about collections accounts that you're going to turn over to the attorney, you go into executive session. And then we'll talk about the minutes here in a second. And then finally, the matters constitutionally, statutorily, or judicially protected. They don't really tell you, of course they don't tell you what that means, what the list is, but typically it's, what I see it for associations is often when you're talking about medical records, for example, if somebody's disabled and they're trying to get a reasonable accommodation, you don't want that open, that's federally protected. Bank accounts, you're talking about that, but typically that last bullet point doesn't really get used so much. So let's talk about the minutes in executive session. So you don't want to take minutes during executive session because those minutes are published. And then if you take information down in minutes during executive session, then everybody is allowed to review them and it kind of defeats the purpose of executive session. So what the law says is, here are your minutes. Number one, you go into executive session and your minutes should say, we are going into executive session to discuss this category. And you name whatever category that you're going into of those 7 categories. And then when you come out of executive session, like it's 7:10 p.m., we're coming out of executive session, and we took this action. If you actually voted during executive session, it might be we hired the manager or management contract or whatever. Or it might be we decided to levy a special assessment. Whatever it is that you took action for, you should state it when you come out of executive session as part of the minutes. Now for collections, you want to be anonymous. You don't want to say, we decided to turn over Mr. Smith and blah, blah, blah. No, you just say, the opening minutes are, we're going to executive session to talk about 5 delinquent accounts. We came out of executive session and we decided to turn over 3 accounts. You can give anonymous numbers if you want to, just don't say the names. Prior to this law being law, you were allowed to do that. We actually had, this is a true story, an association every annual meeting would put a huge map up on the wall and circle in red all the delinquent homeowners on that map to shame them into paying, and that was allowed, and it worked, but you can't do that anymore. You're not allowed to know. Sorry, I took it, I gave it to you, and I took it away, you know. So it's not best practices, but you can't do that anymore. But anyway, so you just want to step back and not use names. Okay, so the only things you
Will
can't,
Colton Dammer please come to the front desk?
Wow.
Again, would Colton Dammer please come to the front desk?
are you in
Thank
here?
you.
Colton, there?
That mic.
Yeah, okay. So, the only things you can't do in executive session, if you're in there for the appropriate reason, is adopt a rule or regulation or amend articles or bylaws. That's all the statute says you can't do. But remember, you have to be in executive session for the right reason. And don't go into executive session and for the right reason and then start talking about other stuff, because you have to come out before you start talking about other stuff. And then you can take notes. That's what you can use to determine which accounts you turned over. For accounts that you turn over for collections, you have to vote on each of those accounts now for 1137. So you should have a resolution or something in writing saying we approved, each of the accounts. Wow, that's loud. Okay.
May I ask you a question?
Oh, I think Becky is taking care of it.
She did.
Oh, there she goes. We should all clap when she comes back in.
May I
Okay.
ask a quick question?
Oh, yeah.
So we're gonna have a board meeting in a week, and we are adding executive session as just a standard line item in case we need to go into it.
Okay.
And I'm recording secretary, so if we do not need to go into it.
Thank
should
you,
I
Becky.
Should I say on the minutes, no need to do, or something like that?
Yeah, so the question was, there's a standing line item on this association's agenda for executive session. And if there is not, and so what you can do is just say, no executive session.
Just not address.
Yeah, we have nothing in the executive session. Okay, the other thing that you need to know about with board meetings that a lot of boards don't know is this became law about 5-6 years ago, is if you're at a board meeting and homeowners are present, then prior to voting, you have to open up that decision to the homeowners present for input and feedback. It's not to vote on anything, but to provide input and feedback. The idea is that associations want boards to make informed decisions. So if homeowners are in the audience, then that is intended to give more information for the board to make a good decision. Remember, it's just to give input and feedback, not to vote, and not to hijack the meeting either. So as long as you do that prior to taking action, then you're good. Also, if there's a particular hot item and it's gonna get a lot of people to come to that meeting, that doesn't mean, for example, you have 100 people show up for this one thing. You don't have to have every single person speak. You have the right to say a reasonable number of people can speak. So pick 10 amongst yourselves, and those people can speak. You have the right to do that. You also have the right to establish a reasonable time frame for each person. So if there's 5 people there, you can say 3 minutes each, or 10 minutes each, or whatever. And not 10 minutes. But if there's 2 people, maybe 10 minutes, so it's up to you to do that. You have the authority to do that. Okay. Okay, this one's really important too. Action without a meeting, because I see this happens quite a bit, where I see a lot of boards messing up here too. What action without a meeting means is email. If boards are taking action by email, they're not meeting in person or virtually, they're just voting on the action by email, then you need to follow your bylaws. And if your bylaws don't say anything, you follow the statute. But you absolutely have to check your bylaws. I'd say 40% of them, and I'm not kidding, maybe even 50, say that taking action without a meeting requires unanimous consent. So, wow, Becky? No, okay, so most bylaws say you have to have unanimous consent to take email votes for board meetings. So just look at your bylaws. Don't look for the term email, and because they usually don't say email. Look for something that says action without meeting, or consent to corporate action, or informal action by directors. That's the kind of language you look for. And if it says unanimous, then unanimous, that's what it means. Every single board member has to say yes. If you don't like that, then amend it out, because most likely you as a board can amend that provision out.
If every member that makes quorum.
Yeah, you could amend it to say quorum, just like a regular board meeting if you want to. But if your bylaws already say unanimous, you must follow that until you amend that provision out. Now, statute provides this default process. So let's say your bylaws are completely silent on how boards take action by email. This is what you can follow. Just really quickly, all it says is send an email to all the directors with a deadline, as long as a majority of the directors in office respond with a yes, and no board members demand an in-person meeting by the deadline, then you're good. That's what the statute says. It's already written up there. But if you already have unanimous, then you have to follow that. Yes, sir.
Are email notices eliminated if you have some people that do not have email?
Well, first of all, email notices aren't required. So if you decide to adopt, for example, let's say a special meeting of the board, and you want to notify the board, and you send emails, but one of the board members does not have email, then you have a duty to either call them or send them snail mail. Notify them some other way. You still have the duty to notify them, but if they don't have email, then you need to notify them some other way. And that's for board meetings. For homeowner meetings, emails cannot take place of the actual mailed notice for annual meetings. They're only given in addition to, not in lieu of the mailed notice. Okay? All right, now we're shifting gears for the second part of this class. I know I see the tired people. Only one more. Should we get up and do some exercise? No. Okay. So this second piece is about protecting yourself from liability, minimizing liability. And there's two overarching principles you have to keep in mind. Fiduciary duty and business judgment rule. Let's talk about both of them. So fiduciary duty, can anybody tell me what that means, fiduciary duty? Anyone?
Something about money.
Something about money, yeah, kind of, yes?
The responsibility to set your own personal needs
Aside?
in favor of the people you represent.
Right, so like when it comes to money, you're being entrusted. It's a position of trust. And so you have a fiduciary with respect to the finances and with respect to any decisions, you need to act in the corporation's best interest, okay? So as a fiduciary, you have to act, your fiduciary is owed to the association, not to the homeowners. Everybody thinks it's to the homeowners. You as a board represent the association, the corporate entity. You could have, if you turned around tomorrow and said, and sent out a survey to all your homeowners and said, do you want us to raise dues? What would everybody say? No, right? But as a board member, you take off your homeowner hat, you put on your board member hat, and you know you have to raise dues in order to pay bills. So you are acting contrary to 95% of what the homeowners want, but you're still appropriately acting as a fiduciary to the corporate entity, okay? So what are the fiduciary duties? Duty of care, all these four things. We're gonna go and talk about duty of care sort of into detail, but let me talk about the last two really quickly. Duty of obedience really just means obey the law, obey the governing documents. And that means you have to know what's in your governing documents to obey them. And if your documents are old, you better know what the law says in terms of superseding those documents or amend them to bring them current. But obey the law, obey the governing documents. Confidentiality, as board members, sometimes information is brought to you that's confidential. And every once in a while we'll see somebody get on the board because they want to take down the board. They're the rogue board member. They get confidential information and then they want to leak it so they can take down the board. Well, they're shooting themselves in the foot because that's a breach of confidentiality. So what happens is if somebody sues the board for the very thing that this whistleblower is trying to address, and that whistleblower also gets sued, the D&O insurance, the directors and officers insurance, will likely defend all the other board members except this one, because this one breached their duty of confidentiality. So don't do that. If you think that board is not doing a good job, then your job is to get other people on the board instead of trying to take down the board internally. Okay, let's talk about duty of care. So duty of care, this is the most important slide because this is what keeps you out of liability. So if a board's decision is challenged, this is the standard of care. These are the questions that the court's going to ask in determining whether you acted appropriately as a board. The court's going to say, well, in making that decision or taking that action, did the board member act in good faith with the best interests of the association and prudently? I'll talk about each one. Now, in good faith sounds really easy. Just means not in bad faith. Don't act maliciously. Don't act wantonly. Act in good faith. And it sounds easier than it is. So you tell me, is there anybody in your community that I would like to call the neighborhood naysayer that comes to every board member or board meeting and challenges every... Does anybody have any of those? No, yeah. You're lying if you don't raise your... So there's like a lot of ones and then there's like...
Yeah, shoot 'em.
So the neighborhood naysayer. So I go to board meetings a lot and I'm there to oftentimes speak to a homeowner. And I've never seen that homeowner before, the neighborhood naysayer. I'll be sitting in that board meeting room and somebody will walk in and I'll know exactly who that person is. And that's because the body language of all the board members totally changes. They're doing this, they're like, rolling their eyes and they're like, oh my God, And so I know that. And that means something. That means that, guess what? You're probably treating this person differently. And that's where you get in trouble. This person who has been challenging every decision all year, then all of a sudden they come up and they give you an architectural review committee request and you're looking at trying to find ways to reject it. You're making them jump through additional hoops. One of the main claims against board members today is non-uniform treatment. That is a breach of fiduciary duty claim, and it's often this neighborhood naysayer. And those of you who have played this before, because I know some people here have been to my classes, I am going to test this out on each of you tonight with a little test, okay, a little exercise. I am going to say a word, and I want you to repeat the word 10 times out loud, and then I'm going to ask you a question. I want you to respond immediately out loud, okay? I'm going to give you a word. You're going to say it 10 times. I'm going to ask you a question. You're going to respond out loud immediately, okay? All right. The word is spot. Ready? Spot, 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 spot. What do you do at a green light?
Go.
I heard go over here, but I heard stop. I usually go. I heard a lot of stops. Who said stop? What do you do at a green light? You stop, right? You hear spot, 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 spot. You hear no, 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 no. You hear blah, 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 blah. You're conditioned to respond a certain way, and that's what happens. That's where you get burned. With this particular, I've seen it happen many times. They'll pull out a paper trail of how you treated them differently, and they're going to win. So you just got to be careful. So with the best interest of the association, that means not in your best interests. Your interests might not align with the association. I had a couple of board members that got in trouble because they didn't vote in favor of a special assessment. It got revealed that they didn't vote in favor of a special assessment because they couldn't pay it. So that's a breach of fiduciary duty right there if you know the special assessment is necessary. So act in the best interest of the corporation, not your best interest, not the board's best interest, not the particularly loud homeowner's best interest, not the nicest homeowners. I'll give you 2 examples. Okay, one is Little Miss Smith, really friendly lady. She's a registered nurse. These are real examples. Registered nurse, comes to every board meeting, very friendly, supports every decision, and she works at night and sleeps during the day, and lives in this patio home community with a lot of patio homes close together. And the board, she was always so nice, and the board said, well, is there anything we can do for you, Mrs. Smith, one night, you know? And she said, well, I can't really sleep during the day because of these wind chimes that I keep hearing, these wind chimes. And they said, okay, well, we got to do something good for Mrs. Smith. So they adopted a rule prohibiting wind chimes. And that annual meeting, they had the largest attendance they've ever had at an annual meeting. And it was, why do you think that is? So many people had wind chimes. They had maybe 30% of the homeowners had wind chimes. They didn't do their due diligence to see whether this rule made sense for the community. They were just trying to help one person. Not good. They're doing their duty for one person and not for the community. Another real example. We had an association with 6 condos, and this is important for you to understand, because if it looks or smells like preferential treatment to the board, that's what it's going to be thought to be. They're going to say they adopted that to help the board or a board member. So we had 6 condos, and one of the board members lived in building number 2. And that board member, everybody knew, was about to sell their unit. So they were going into a painting project for this community, and lo and behold, building number 2 got painted first. So everybody was like in an uproar, going, oh my gosh, you know, they did that for the board member in building number 2. Now why would that be okay for building number 2? That smells bad, right? It seems like they were doing it for that board member. But why couldn't it have been fine? Anybody can think of any reason?
Worst condition of the thing.
So this is actually true. The contractor said this is the worst building in the community. We should paint it first. The other reason why, it was the first building that you see when you drive into the community. It was building number 2. That was the only reason, but everybody was thinking that the board did something improper. So just make sure that you paper trail if there's anything that it's an objective decision. What did you do in order to make that prudent, informed decision? So the prudent just means ask a lot of questions, particularly if it means a lot of money is going to be spent, because those are the decisions that are challenged the most. You don't have to, you don't have to ask questions about, or financials about, for example, just every contract you're paying a bill that's the same amount every month. But if you're entering into some large contract with a lot of money, make sure you asked, all your management company is as good, your attorney, your whomever, the engineer, if you're doing it correctly. If you make an informed decision and you show it's in the best interest of the association and you act in good faith, you're going to be protected. So here are some ways you can be informed to show that you're making informed decisions. Read, be familiar with, and know what the law is in the governing documents. The worst thing is if you don't even know your quorum, and then you take action, and it turns out the action is invalid because there was no quorum. I mean, these are things that you need to know. Be familiar and follow the laws. Just know what they are. Attend meetings and participate. If you're not attending board meetings and you're not doing it regularly, just get off the board, because that's doing everybody a disservice. And you should attend them if you want to be on the board. Hire and follow advice from qualified professionals. Don't go to a fly-by-night company. Hire somebody that is an expert. You know, don't go to a divorce attorney for HOA law. Okay? In fact, that should say, hire and follow advice from Altitude Community Law. Read and understand your board packets before you get to the meeting, because you're supposed to make decisions at the meeting and ask questions. Otherwise, you're tabling it over and over and over again. You can rely on expert opinions, on reports, statements, committees. You don't have to go out and become an engineer or attorney to get the advice. You can rely on others who have expertise. And that's fine under the law. Law says you can go ahead and do that. So here's the best thing. If you show that you acted according to that standard of care, the courts say that you have the right to have, it's called the business judgment rule, which essentially says you have the right to make business judgment decisions according to that standard. And if you do that and can show it, you're not liable even if you're wrong. So you could, for example, get sued, and then the judge finds against you. He still won't, he won't hold you liable as long as you show that, hey, I acted in good faith. I hired an attorney, an HOA attorney, not our law firm, because you would win if you hired our law firm. But I hired an attorney, and they gave me bad advice. But guess what? I was prudent. I acted in the best interest. You're not going to be liable. So just remember that, and paper trail that you did that you asked a lot of questions, that you got opinions, that you have in the minutes that you acted in good faith. Whatever it is, just paper trail it. So that's what keeps you out of liability, is acting according to that standard of care. And really quickly, let's talk about conflict of interest. That's the last duty. And that's essentially just, it's a financial or other transaction that you as a director want to enter into with the association, where you're going to get financial benefit, or somebody you're related to is going to get financial benefit, or a company that you have an interest in is going to get financial benefit. So that's a very simple example is you own a landscaping company and you want the association to hire it. That is a conflict of interest because you're going to get money out of that deal if the association hires it. Or hires your company. That doesn't mean it's void, because it could be the best contract. And why should you forego it just because that company happens to be owned by one of the board members? All you have to do is disclose it. And the majority of the disinterested directors, I mean, that says you can disclose it at an annual meeting, but typically what happens is you disclose it at a board meeting. Because the board members are the ones that are going to enter into the contract anyway. So you would disclose that conflict, and as long as it's fair to the association, and the disinterested board members vote in favor of it, then it's valid. Okay? So what you want to do is make sure that you have a conflict of interest policy. This is one of the 9 that I mentioned previously. So the conflict of interest policy should say that the director with a conflict disclosed the conflict, abstained from voting. Now, you're not required to under law, but we recommend that the board member who has the conflict recuses him or herself from that decision, as well as participating in the discussion, because that board member could have additional ways of influencing the board if they're in that meeting. So the conflict of interest policy should say they should disclose, abstain, don't participate in the discussion, and leave meeting during the discussion, and then the remaining board members should vote on it. Have the policy in place now, because again, this is one of the 9 that you're required to have. Okay, couple of things, we're shifting again, just a couple of tips to safeguard your association. Number 1, this is a very important one, obtain broad directors and officers liability insurance. What is that? That's D&O insurance That's the insurance that protects you and defends you and pays for your defense if you get sued individually. And that's why you want it, because it costs a lot of money to defend a claim against the board. Even though 99% of the time those claims are bogus, you still have to defend it. So you want a good, thorough D&O policy. So make sure that it's a standalone D&O policy. It's not just some little rider that comes along with your commercial general liability policy. A standalone director policy that covers everyone. It shouldn't just say directors are covered. Because what about committee members? What about officers who aren't directors? What about other volunteers? It should be very broad. Directors, officers, committee members, volunteers, anybody who acts on behalf of the association. The types of claim, make sure that the policy covers non-monetary claims. Non-monetary. They'll know what you're talking about, the insurance brokers. You don't want a policy that just gets triggered by money claims, because usually you're not getting sued for money. You're getting sued to overturn a decision that somebody doesn't like. And if they're suing you to overturn a decision or something like breach of fiduciary duty, but there's no money involved, your D&O policy will not get triggered. So make sure it covers things like breach of fiduciary duty, negligence, all those things that don't involve money. They involve the practice and the decision making. Yes?
Are you saying that we should do this individually?
No, I'm sorry, good question. This is what your association should be getting, a D&O policy for you. You don't have to get any insurance for yourself. This is what your association should be purchasing. It's not even required by Colorado law, it should be, but a lot of documents require it. Amounts, that depends. I mean, I think that typically I see $2 million as the standard amount, but you should just talk to your carrier depending on your claims history. Indemnification provision, this is extremely important. We talked earlier about indemnification provisions being in your bylaws. So indemnification means defend. This provision works in conjunction with the D&O policy. It means that if somebody is being sued individually, then the association shall indemnify them, shall defend them, shall file a D&O claim to protect them and to defend them. And we have had situations where the bylaws did not contain an indemnification provision, or it contained one that said may indemnify. And this actually happened with one of my associations where a board member was recalled from the board, so they were off the board. A homeowner sued that recalled board member. The remaining directors sided with the homeowner and refused to file a D&O claim to defend that board member because their bylaws said that the association may defend. So look to your bylaws and make sure that they say shall indemnify, because that will work in conjunction with the D&O insurance policy. So these next two slides, and I promise I'm not trying to line my pockets, I don't care who your attorney is, but this is so necessary if your documents are over 15 years old, maybe 20 years old. Get a document review. Yes?
When you say it's D&O, is that for an individual or a position?
It's for an individual, and it's D&O, Directors and Officers Insurance. Even though it's called Directors and Officers, D&O, it should extend to any other individual who's acting on behalf of the association. Okay, get a document review. Just because you need to know what's contrary to Colorado law and whether you're following good documents or not. We do so much of this now. I'd say 10 years ago, I did some amendments. Now all I seem to be doing is rewriting documents. But you really need to know it simply because the law has changed quite a bit. And when you find the contrary provisions or things that don't make sense for today's community, you need to amend. Because I told you the number one claim against boards is non-uniform enforcement. The number two claims is failure to enforce a clear provision in the documents. So if you have something in there that says parking on the driveway is prohibited, or no motorcycles on the driveway or whatever, and you're not enforcing it, that's just as bad as non-uniform enforcement. Boards get sued all the time for that. So just be careful. If it's in there and you're not enforcing it, then amend to get rid of it. Yes?
Quick, do you have a rule of thumb on possible costs of these things
For a document review, I think we charge, oh my God, this is being cut. This is recorded, so I don't remember. It's right around 1,500, I think. You know, and then that comes with a report. But for you, it's 2,500. Yes.
It's not based on the size of your HOA?
No, because it takes the same amount of time. Yeah, I think it's 1,700. I'm not really sure, but anyway, call me or talk to me afterward. Yes.
Well, should you do that like annually or every 3
No.
years or what?
So the question is, should you do it annually? No. I'm saying if your documents are maybe 15 or 20 years old, right around there, you definitely need to do it. If you've had them rewritten recently, then you don't need to do it. For those in condos particularly, there's been a lot of insurance questions. So just the condo owners, get an insurance audit. If you're having insurance premiums that are skyrocketing and you want to figure out what to do, the first thing you want to know is if you're over covered, if your coverage is more than it should be. That's one thing that we're doing. Also, ways to facilitate the deductible, all of that. So for condos, definitely get an insurance audit. Always comply with and understand your governing documents, or amend if applicable, because again, you want to get rid of it if it no longer makes sense for your community, or you want to add it if there are gaps. I'd say probably the number one addition we get asked is no short-term rentals, Airbnbs. That's a very big trending topic. If you have something that's a gap, you might want to fill it. That's what you need to do, is amend your documents to do that. Okay, and we already talked about making informed and prudent decisions and paper trailing. So again, for the decisions and paper trailing, it's really key to address it when it comes to the monetary, the huge costs. Those are the ones that are challenged the most. So those are the ones that you really ought to show that you were acting informed. Yes?
So I have a question, because this came up in a discussion, and it was, as board members, we have working papers. Should we keep those or should we get rid of them? And
So
what
great
about-
question.
And specific about email, because there's a lot of that on email. So what is your advice?
So the question was, there's a lot of paperwork, a lot of documents. Should we keep everything? Okay, so many of you might not know this, but certain documents you're required to keep permanently. That means permanently. All minutes must be kept permanently per the statute. Emails, I heard, oh yeah. So emails. So let's say you're emailing back and forth and you make a decision as a board via email. Remember we talked how to do that? So what the law says is all those emails leading up to that decision by email are open to inspection by homeowners. And the emails that show how it was voted, like the yeses and nos, they are required to be kept permanently. So there's a lot of things under the statute that say which records you're required to keep and for how long. There's only a few that say for how long, and then they don't talk about the others. What we recommend is getting a document retention policy in place. This is different from the inspection of records policy I talked about. That's one of the 9s. It is a policy that lists all the documents of your association and then time frames for how long you're going to keep them. And for those documents that don't fall under statutory requirement, you would probably, you do best practices, like 4 years after a contract, 7 years after whatever. And then you have a provision in that that says when you purge those documents. So it'll say how long you retain them, and every year you purge whichever ones meet that criteria, so that you're not held to that later, trying to find something. 1 second, this lady, yes?
When you say that, are you saying that the property manager has to keep that entire paper trail, or
The board? Right. So the document retention policy would clarify that. Because most of the time, the management company maintains the records, right? Most of the time. And this protects the management company too, because if you have that purge thing, then the management company knows to just get rid of all of them, everything in this box. But that would be clarified in the policy. Also, emails that go back and forth between board members but don't lead to a decision, those aren't open for inspection. But guess what? If you're sued, they will be discoverable. So here's the lesson there. Here's a tip. Number 1, if you are going to make a decision via email, a very specific decision, be very regimented in that process. That email should say, this email is for the sole purpose of considering and voting on the landscape contract. That way, hopefully the board members will stick to that topic. Because if you're not that regimented, then all of a sudden you're saying all these other things and they could be blown up in court, completely taken out of context, informally, and because of some lawsuit, but they're discoverable. So be very, very specific and clear that this is the thread. Because remember what I just said? That thread leading up to the decision is open for inspection by homeowners. So you want to be regimented. Number 2, don't use your personal or work email address for HOA business. Do not do that. Have a generic, board president at blah blah gmail.com, board treasurer, whatever. Because again, if you get sued, they can take the emails from any email that you use for HOA business. And if that's your personal email, they can look at your personal ones. If that's your work email, they can ask for your work email. Number 3, if you decide to email a lot, and I'm not a big fan of email, I just am not. I don't think that if you do email votes, you don't have the same kind of vetting that you do if it's in person and all that. But if you are communicating regularly by email, whatever you write it as if you're going to say it at the annual meeting. Don't write it informally, because again, you start getting in trouble by informally saying something and all of a sudden you say something really that could be horrible, and it'll be in the thread and it'll be taken out of context. So try to act and write in a more regimented, professional manner in any email, even if it's not going to a decision by email, because you could get sued and it could be discovered. Yeah.
Can we talk for just a moment about bids?
Yeah, sure.
If there is a semi-formal
Process or something?
process
Yeah.
where the management goes out and asks for bids,
So right now,
is there a requirement for a bid model?
so the question is, the discussion topic is bids. So bids for various projects, for construction projects. There's nothing under Colorado law that requires you to go into a bid process. There's nothing. A lot of associations do it over a certain amount. So I don't know what that, if any management companies have a thought on what that amount is, but typically it's a larger contract, not the ones that are, 5,000 or 7,000 or something, but the larger ones. And typically what happens is they'll get 3 bids and they're closed and only the board is reviewing them. And it's often in a process. If you enter into a lot of large projects, or something is coming up where you're gonna have to spend a lot of money, it's good to have a bid process. The one thing that statute, the provision where I talked about records that you have discretion to withhold, bids that's one of those records, which I would recommend holding bids before you and not publishing them. But that's one of the records that you are entitled to withhold from homeowners. Contracts, once you get them signed, must be open for inspection. Okay, any more? Yeah.
Text messages.
Text messages are just like association records, same thing. It's some communication form that is outside an actual meeting. So I would treat them the same. If you see, if the statute says electronic, it says, it's very broad. Any communication in writing that leads up to that decision in via email or text is open for inspection. Okay, let's move on because we're almost done here. Top 3 things board members should not do. Does anybody remember this movie? I always forget what this movie is called. Do you guys remember this one? Truman Show. Truman Show. Okay, yeah. So Truman Show. So I put that up there because, you know, as board members, you are under scrutiny. You are under, they're watching. You know, and unfortunately, it's weird. It's weird what happens is you get on the, you're a homeowner like everybody else. Then you get on the board and all of a sudden this invisible wall comes up and it's us against them. We want to break that down because that's you're just steering the ship like everybody should do at some point. But you are scrutinized for your decisions and you're watched, and you also want to show, originally we were talking about making sure that you know the pulse of the community. So that the number one thing you want to do is not act in a vacuum as a board. And I know that's difficult because, and what I mean by that is try to get input, feedback, and try to get people to come to your board meetings. Because it's difficult because boards, they don't want to act in a vacuum, but nobody shows up at the meeting. But the best way to stop challenges is to be very transparent and to open and to over communicate what's happening at board meetings and invite people to come, especially if it's going to lead to a big decision. So why? Are there legal requirements and what are the practical consequences? Legal requirements. Is there a legal requirement to seek input? Yes, we talked about one of them. If you're at a board meeting, you have to seek input from those owners who were in attendance. Also, remember those 9 policies? One of those policies, of course, the legislature thought this was so smart. So you have to do all these policies, and you also have to have a policy on how to adopt a policy. So that is one of those 9 policies. So your adoption of policy might actually say, before we adopt rules and regulations, we need to seek input. That's not required for Colorado law, but it might say that in your policy. So practical consequences of acting in a vacuum or not seeking input. Homeowners are blindsided, lose credibility. There could be financial consequences. Where I've seen this happen is, for example, a special assessment. If it's huge, have an informational meeting. Don't just, even if you have the right to levy the special assessment without any kind of board approval or homeowner approval, talk about it. Say, this is coming, this is why. Here are all the reasons why it's necessary. Getting a loan, same thing. Any kind of big decision, try to have informational meetings. Otherwise, again, you lose credibility because they think you're just making decisions willy-nilly. Yes?
Special assessment, don't you have to go to the community with a new budget showing how it's going to be used?
You do for most. Okay, so special assessments aren't addressed in the statute. So what we've always said is a special assessment, it's the lump sum that's levied in the middle of the year. Treat it as an amendment to the budget, which then requires homeowners the opportunity to veto the budget or veto the special assessment. Some older documents for pre-Kiowa say that the board has a right to levy special assessments for certain reasons. You probably could still argue that that is allowed, and in those cases what I would say is still have the informational meeting, but to be absolutely prudent the way the statute is working or the legislature, I would still go and do the veto process, even if it says that you can levy a special assessment without homeowner approval. In my opinion, it'd be better to just still open it up for a veto.
That would be for all the owners in the meeting?
So it's just like a budget veto, which is you set a meeting and the majority of the entire community must veto it or it's deemed approved. So it's very different from approval. So do this instead, seek input, use committees, be transparent. We talked all about that. Number 2, please don't micromanage. I don't know if you can read that on there, but I always thought that was really funny. But that's probably, I always see this in terms of both board members and managers. You hire a management company, let them do their job, and don't micromanage the management company. These are just, if you do any of this, then you are a micromanager, okay? You can read that on your own, but you are definitely a micromanager, and this happens all the time. Don't do that, because guess what? Board members, well, there's no law that says don't micromanage, but practical consequences, shows lack of trust, creates more paperwork, more emails, wastes time, reduces motivation. All these things happen if you micromanage somebody, and you don't want to do that. Do this instead. Avoid the day-to-day decision making. Stop having meetings between meetings. It can wait till the next meeting. Stop having a gazillion emails between meetings. It can wait till the next meeting unless it's an emergency. And trust in others. Because really when it comes, micromanaging really comes to trust. Number 3, does anybody know who that is? My generation maybe knows who that is. My favorite bully. That's Biff. Don't be a bully. Whoops. Did I put that? Yeah, don't be a bully or don't let people bully. This happens, and I'm not talking just about this kind of bully. You know, there's a lot of different kinds of bullies. I'm sure you recognize some of those. I tried to get the younger crowd in there. I got the Harry Potter guy up there, and then my generation. But don't let bullies continue. And I'm going to talk about really quickly each one. Intimidator, that's the easy one. The one that's yelling, shouting, foul language, and all that. I have a class just on bullies. I have a class on dysfunctional boards because this is what happens, you know. Negative impact, board members quit all the time. If you got a yeller, board members quit, management quits. This is a sneaky bully, the get a life bully. This is the bully that starts off as an advocate and then becomes over-involved in every single thing. I think this is more of an ego thing, and maybe this person had a really important job or something before, and it controlled some Fortune 500, who knows. But the negative impact here that I see, contractors and vendors quit. Because you're imposing your own kind of expertise where you hired somebody to do it. So, and then finally the expert, kind of like the get a life bully. But this is important because you could be an attorney, you could be an engineer, you could be an expert in a particular category that might fit within whatever project you're moving towards as a board. And if you get involved, if you use your expertise, then again, you might be losing that protection that you get as a volunteer board member because all of a sudden you're an expert and you're using your expertise. So try to, step back and let the other engineer do it or let the whomever, because it could remove liability protection. Legal requirements, again, there's no law. Here are all the practical consequences, disruptive meetings, all of this stuff. Can you remove a board member who's a bully? Some say yes. Anybody say no? Somebody should say no because that was the give there, right there. Yeah, it could be no. So, only homeowners can only homeowners can remove homeowner elected board members. So if a board member was elected on by homeowners, doesn't matter what your bylaws say, only homeowners can recall them or remove them. Now, if a board was filling a vacancy, they appointed somebody in, then the board can remove that appointed board member. But board members cannot remove other board members. Yes?
What if a board member is volunteer and there is no vote, they just volunteer?
So if there was no vote and they weren't elected in and they were just volunteer, so that means the board essentially appointed them in, then the board can remove them. So another thing you should know really quickly about board members, because that situation, so let's say your term is up this year and you go to the annual election and there's no quorum, then you can't elect anyone because there's no quorum. So the board members whose terms are up continue to serve until the next election unless they resign. If they resign, then other board members can appoint in that vacancy. Just realize that they have to resign though. They continue to serve. All of you will continue to serve until you die. No, I'm just kidding. So you need to learn how to resign. No. Yes.
In the bylaws that a board member has to attend all except 3
Great
meetings, and you have a member that is just not attending meetings.
Right. Okay, so there's a difference between removing a board member and a board member that is disqualified, can no longer serve. And that has to do with the qualification section. So remember we talked about this earlier about how you could put board member qualifications in the bylaws. This is what the board member, so for example, a lot of bylaws will say you have to be current in your dues. You have to be not suing the association, whatever it is. If they're serving on the board and all of a sudden they become delinquent in their assessments, then they're disqualified. That's not the same thing as removing them. Okay? Okay, so for the bullies, just confront it early on. Oh, did we have a hand back there? Yes.
So if you're a board member and say you're on it for a while and then you decide you don't want to be on there anymore, you can just resign.
No, you can never resign. Yeah. Yes, you can resign at any time. Don't worry, because a lot of them are like, we don't want to be on the board because we can never leave. No, you can always leave. Well, you can leave the board position by moving out, by resigning, or by dying. It says that, death, removal, or they sell their unit. So, yeah, you can always resign. Yeah.
Are there term limits for board members?
Not necessarily. I mean, some documents put them in there, but I would always say take them out. If you put term limits in there, it might be, you are really reducing the pool of people who are willing to serve. So if you do have term limits, I would say get rid of them because nobody wants to serve on the board. Okay. So just confront early on, be specific about the behavior, and then just remove them if you have to. But remember, homeowners have to remove elected board members. That is all, everybody. So I finished 15 minutes ahead. Thank you. I will answer a few questions. Yes?
Okay. The house is in the wife's name.
That's how it should be. Yes. What was that?
The husband wants to be on board.
Who's on the deed? Whose name is on the deed? The wife. Then the wife can only be on the deed if it says only owners. The wife can quit claim to the husband. Shouldn't do that though. No. So yeah, if it says that you have to be an owner, that means record owner. That means on the deed.
And that would apply to the art committee and things of that nature?
Possibly.
Okay.
It depends on the art committee. What else? Yes?
Can you have a special assessment only aimed towards a certain group of people?
Special assessments, can they be levied only? I want to respect everybody's time. Thank you for coming. You have to leave, but I will answer a few questions. Thank you. So you can have a special assessment against only certain people or categories if specified in the documents, because most of them don't do that. They say all special assessments are levied against everyone. Yeah?
Isn't there a Colorado law right now that kind of cuts HOAs off the means of
Enforcement? Yes.
of those things?
Yes, HB 22-1137 guts the association's enforcement rights. It's pretty it's pretty complicated. So that we have stuff like that on our website though. We have an actually, if you want to come up and I will or email me or get my card, I will send you that information. Okay? Thank you everybody